Hi, welcome to the Blockchain Law Show. I'm your host, Anki Kwan. In this episode, I wanted to talk about the SEC's recently published framework for ICOs. This was highly anticipated. The crypto community had asked the SEC for more guidance on whether their ICOs are offers and sales of securities and when the securities laws apply to ICOs, and the SEC has now delivered. It also issued its first no action letter to a company that's looking to do an ICO. I'm going to talk about that in another video, and in this video I'm going to focus on the SEC's framework. The framework isn't exactly surprising. It reiterated what the SEC has said in past enforcement actions and in past statements, but this is supposed to be a framework that is usable and understandable for someone without a legal background, and it's supposed to help you think about whether the ICO you're contemplating has to be registered with the SEC or has to qualify for an exemption. If you're offering or selling securities in the United States, you have to either register your offering or find an exemption that you can use that exempts you from registration. That means the first thing you have to do is figure out whether your ICO is considered the offer and sale of a security. The definition of a security can be found in the Securities Act of 1933 and the Exchange Act of 1934. One of the definitions of a security is an investment contract. This is a definition that's meant to capture new ways of raising money. Because of this, the SEC used this definition to determine whether ICOs are subject to the US securities laws. The test for an investment contract was created by the Supreme Court in a case against a guy named Howey. It says that there is an investment contract where there's an investment of money in a common enterprise where the buyer reasonably expects profits from the efforts of others. This is the efforts of the company doing the ICO or the promoters of the ICO. In the ICO space, what this means is that the promoters or the company are using efforts to make the tokens more valuable. This means developing the network, making the tokens more valuable by burning the tokens, buying it back at a premium, creating a secondary market for the tokens, and anything else that the company or promoters do that affects either the success or failure of the tokens and the price of those tokens. That's what the SEC is looking for. They're looking for whether the company or the promoters of the ICO are essential in making the tokens more valuable and the enterprise more successful, thereby impacting the value of tokens for the buyers. The framework that the SEC published has really great examples of what the SEC looks at when they consider whether an ICO is a security. And I highly recommend looking at those examples if you want details on what the SEC finds pertinent in their analysis. I just wanted to call out a few things that stuck out to me, and I think that what's pertinent is that a lot of the ICOs that we've been seeing in 2017 and 2018 and through the SEC's enforcement actions, all of those ICOs would be considered offers and sales of securities in the eyes of the SEC. For example, if you're selling tokens and using those tokens to develop a network, that would be a factor that works against you in the SEC's analysis of whether you're offering and selling securities. If you're creating a market for these tokens, then that would also suggest that you're offering and selling securities. If you're making these tokens more valuable, for example, either by developing the network, by burning the tokens, by manipulating the value of the tokens, that's also another factor suggesting that these are not actually tokens that are meant to be used for consumption, but they're securities. The SEC also gave an example of an ICO that wouldn't be considered a security, and this is the functional equivalent of selling gift cards. If you're operating an online store and you sold tokens that could be immediately exchanged for goods and services in your store, then that isn't likely to be subject to the securities laws. But you have to make sure that you're not doing anything to increase the value of the tokens, for example, by buying them back at a premium or putting it on a secondary market, or allowing the tokens to be used anywhere else but your store. If the tokens can only be used within your store in exchange for goods and services, and the value is stable, then it's likely that you're not offering and selling a security. And the example they gave is in line with analysis they gave in their no action letter to a company called Turnkey Jet Inc. I hope you found this video helpful and this helps you think about when an ICO may be the offer and sale of a security, which would subject you to US securities laws. In a nutshell, if you're selling tokens that function like gift cards, or they function as prepayment for goods and services, then you're likely not subject to the US securities laws. Whereas if you're selling tokens that are meant to be increased in value, then it's likely that you're selling securities. I hope you found this video helpful. If you did, please share. Thanks so much for tuning in, and I hope you have a great day.